So although it's not absolutely necessary to get a new edition of the textbook, I would do that if I were you, because using the old edition will make your job more difficult. And then today I posted a further announcement that's relevant to that question. Today we will cover in class Chapter 4 from the 14th edition, which in the 13th edition is Chapter 3. And so I wanted to make sure that people were not confused about what is covered on midterm number 1 on September 29th. So take a look at the announcement that was posted today or not today, it was posted on Friday, the 11th of September. It clarifies what sort of chapters you need to study out of the 14th edition. And finally, if you have not yet done so, please send me your selection for which option number 1 or 2 or 3 you select for midterm number 1. Does anyone have any questions about any of that? All right. So let's start on page 388. The heading near the bottom of the page is employer's liability to third persons or third parties, and it describes on these 2 pages a concept that is relevant to Chapter 5 on tort law. Chapter 4 on tort law, Chapter 4. And what we will be looking at in Chapter 4 is different kinds of torts, including the tort of negligence. But as an intro, look on page 388 under the heading Liability and Contract. And here we're talking about what sort of responsibility does an employer have when it makes a promise under a contract and then uses employees to carry out that promise, the contractual promise. So imagine that I own a business and I make contracts with people to cut their lawns and shovel their snow in the winter. And I make a contract with you for my business to cut your lawn. It's highly likely that you hired me to get your lawn cut as opposed to seeing me cut your lawn. And so I can probably safely use employees to carry out the promise that I made under the contract. What if those employees do not properly keep the promise that I have made under the contract? That's what's discussed on page 388 under the heading Liability in Contract. It says, often parties to a contract do not intend to perform personally. Corporations cannot do so, and they expect employees or independent contractors will perform. The promisor, that would be me in the example I've just given you, remains liable for satisfactory performance, as when a construction firm, and then they give you an example. And so when a business makes a promise under a contract, they're called the promisor. They have the obligation under the promise, and it says at the end of the paragraph, the promisor will be liable for breach of contract should its own employees do improper work. Now, nothing there, I'm sure, surprises you. And we'll repeat that idea later in the semester when it comes to the idea of a promisor. But relevant to that is liability in tort. What happens if I tell my employee who's driving my company vehicle, whatever you do, make sure you follow all the rules of the road, stop at stop signs, do not speed, do everything according to the law when you drive the company truck for me. And then, despite those careful instructions by me, the employee, say, speeds and drives through a red light and injures someone who is crossing the street because the employee drove negligently in the company vehicle. See what it says under the heading Liability in Tort. A business is liable for damages to a third party for consequences of any tort an employee may commit in the course of employment. You may wish to underline for emphasis the words "in the course of employment." So whenever an employee is doing work as part of their job, if they commit a tort, and in today's lecture we will look at a number of different kinds of torts, then the employer will be responsible to the victim of the tort for damages committed by the employee in the course of employment. The authors continue. The employer may not have authorized the wrongful act. It is liable even though it has forbidden such conduct. All the injured party need establish is that the employee caused the damage while engaged at work. And on page 389 are 3 illustrations, and you should make a note to yourself after class to read those 3 illustrations. They give you example of an employee called Adair. And whether or not the employer is responsible for the employee depends upon whether or not the tort, like negligence, happened during the course of employment. For example, in illustration 18.3, look at the right-hand side of that illustration on page 389. It says, Adair departed from the course of his employment and embarked upon an independent enterprise, a frolic of his own. And so, if the employee does something like negligence while they're working, the employer will be responsible. If they engage in something like negligence while they're on a frolic of their own, the employer will not be responsible. Well, the test is if it happens in the course of employment. And that's called the Salmon test. At the bottom of page 389, in footnote 7, the authors refer to a text by Salmon and Houston, and Salmon is a well-known English legal writer, and Salmon is credited with the idea of this test of the employer being responsible for torts that the employee may commit in the course of their employment. And the last point I want to cover with you today, before we move to chapter 4, is in the sentence just before the heading, Notice of Termination. And there it says, sometimes when an employer has been liable for the negligence of an employee, there's the right to be indemnified by the employee. So if my employee negligently hurt someone and I must pay damages to the victim of the negligence, it's legally possible that I could recover from the employee. But as a practical matter, often the employee does not have the assets to cover for the loss, and I might not bother as a practical matter to go after the employee. Any questions about that introduction to a concept called vicarious liability? All right, well, today's main topic is tort law in chapter 4. In the old edition, the 13th edition, that is chapter 3. And so turn to page 74 if you have the 14th edition. That's the edition that I will be referring to. And on page 74, there's a heading, Chapter Law of Torts. And somewhere near that heading, Law of Torts, I encourage you to write Civil Wrong, O.J. Simpson, because the example that most people are aware of and can understand regarding what is a tort is the case of O.J. Simpson. Recall that there was a point in time when he was charged criminally for being responsible for the deaths of a couple of people. Had he been convicted by the jury, he would have been imprisoned for that as his punishment. But he was found not guilty under criminal law. Subsequently, O.J. Simpson went through a second trial for civil liability for the civil wrong of the deaths of those people, and he was found responsible civilly for their deaths, and damages were awarded against him in favor of some of the survivors of the deceased. And so a tort is defined in the margin on page 74 as a wrongful act causing harm to the person or property of another. Now, before I go any further, I wanted to repeat something that I've said earlier, and that is when you are preparing for an exam, the best way to prepare is to follow along in class like some of you are doing right now. And while I am lecturing, it's best practice to read along in the textbook and listen to what I'm saying. For most people, the simultaneous reading and listening will help them think about the ideas, so you should actually think while the lecture is going on. And by all means, ask me questions at any time if you have any, either by putting your hand up and getting my attention or typing in the chat. And in earlier lectures, I encouraged you to read certain materials on the course Blackboard site, like, for example, the case of the Spelunkian explorers, or the information about the pecking order that exists in our court system among judges. Does anyone have any questions or comments or concerns about any of those materials posted on Blackboard? Donna. Just waiting for Donna to hit enter so that what she's typing shows up in the chat. And she writes, I've been summarizing and making notes for each chapter in the textbook. Will that help me prepare? Sure, if that process of summarizing helps you, by all means do that. When I present information by referring to specific passages in the textbook, those passages together cumulatively from each chapter are the portions that are relevant to the exam. I will not be asking you any exam questions out of any parts of the text that I do not refer to. And so going through, some people learn by going through the process of summarizing and writing out. That's by all means do that if that works for you. And when it comes to the materials on the course Blackboard site, you only need to read that material through once that I've posted. You do not need to study it for the final exam, but just read it so that you think about it. And for most people, reading it once will help them understand what I've covered in class, and will be sufficient for their memories. When it comes to the final exam, you need to study. And what I mean by that is you actually, for most people, need to read over the important passages as many times as it takes for you to remember them. Does that answer your question, Donna? Great. There's another handout up. Is there another question? Two people typing in the chat. One person typing in the chat. Does the midterm consist of multiple choice and short answers, or? Yes, the midterm will be a combination of multiple choice and short answer questions, mostly multiple choice questions, with a few short answer questions at the end. I see a couple of more people typing in the chat. Is there something more I need to wait for, or can I continue on with? Are some of the questions similar to the illustration? Well, two people typed at the same time. Are some of the questions similar to the illustrations we discussed so far from the chapters that we went through so far? Yes, I would say the answer is yes, quite similar. And the short answers ask you to define and apply concepts. Yes, some of them might be to demonstrate that you understand and remember a certain concept. Others may be that you apply the concept. So there might be a fact situation described, and you need to be able to recognize that a certain concept that we review in class applies. So for example, there might be a fact situation describing something similar to what I just covered with you on pages 388 and 389, and you would need to recognize that that was a situation where the legal concept of vicarious liability was applicable. Exactly so. All right, last call for questions for now. And by the way, I'm very happy with those questions. Always do not hesitate. Feel free to ask questions at any time. So back to page 74. We're talking about tort law today, chapter 4. And you might want to write somewhere near the top of the page or the bottom of the page. There's some white space there, blank space there too. Obligations not based upon consent, agreement, or contract. Obligations not based upon consent, agreement, or contract. Because unlike contract law, and we're going to spend a fair amount of time in our class on contract law, when we're talking about tort law, there's no contract between the parties. Just by virtue of the circumstances, one person will be responsible to the other. So in Ontario, by virtue of being in our society, you need to be careful. You will see that when your actions might injure someone else, you need to act in a way that's careful enough under the circumstances. And we will go through some examples of that. And so on page 74, in the opening 6 lines, the authors do an amazingly good job summarizing what the chapter is about in a very general way. It says the word tort comes from the French word meaning wrong. A tort is an improper behavior by one person that causes injury to another, sometimes intentionally, but more often unintentionally. The injury may be physical to the person or property of the victim, or emotional or financial. And as a general proposition, look at the next sentence. Tort law determines in which circumstances the person who causes the injury must compensate the victim. And that word compensate is important. Look at page 75. It says in the first sentence under the heading Scope of Tort Law that the purpose of tort law is to compensate victims for harm caused by the activities of others. somewhere near the word compensate, after you circle or underline it, you should write generally not to punish. Because as a general proposition, the function or purpose of tort law is not to punish the wrongdoer, but rather to give compensation to the victim. So, in the next paragraph, the second paragraph on page 75, the authors explain that as a general statement, a tort identifies a set of circumstances that creates a right to claim compensation. So when you hear someone say, well, I'm going to sue you for that, often we're talking about tort law, not contract law. Someone will claim that they're entitled to compensation because of something that the other person did. So when someone suffers a loss, an injury, some harm, look at the third line of that paragraph. Who should bear the loss, it says. And then they list a bunch of different people who perhaps could bear the loss. The victim, the person who caused the harm, the group that benefits from the activity, or a larger group like taxpayers. And most people would say, to some extent, each of those people in the list, to some extent, often bear some of the loss. But how much of the loss? That's the next sentence. Tort law is one way of apportioning the loss. So it's a way that will require, under the right circumstances, that the wrongdoer, the person who caused the loss improperly or wrongly, compensates the person who suffered the loss. And that brings us to the historical development of the tort law. And let's start with the definition on page 75 of strict liability. We've covered those points now, that the tort law is there not to punish people, but rather to compensate victims. When it comes to the development of the tort law, strict liability is defined as liability that is imposed based upon causation regardless of fault. That's what it says in the margin. And so in the beginning, the law was merely concerned about who caused this. See what it says in the second sentence under the heading, the development of the tort concept. Anyone who caused direct injury to another had to pay compensation. And initially that's the way it worked. No inquiry, it says, was made into the reasons for the injury or whether the conduct was intentional or unintentional. Then it says, over time, the idea developed that a person should not be responsible for harm caused to another if he acted without fault. And so the focus started to turn to the idea of fault in most cases. And then it says a couple of lines below that, gradually the courts recognized indirect or consequential injuries. And they give you an example at the end of the paragraph that you should read. And so nowadays, the law has evolved to the point as described in the next paragraph where it says, today's tort law involves two principles: the fault of the defendant, that is whether the behavior was improper, and the causation of the harm, that is whether the plaintiff's injury was the result of the defendant's conduct. And today we will review those ideas covered so far on page 74 and 75 in a fair amount of detail. So when we talk about this word fault, what do we mean? Under that heading on page 75 at the bottom, it refers to blameworthy or culpable conduct, or as it says in the second line, unjustifiable because it intentionally or carelessly disregards the interests of others. And so if, as a child, you were given some toys to play with, it's highly likely that one of your parents or other adults said to you, be careful with those toys and put them away when you're done. And if you don't and they get broken, we will not fix them. You will suffer the consequences of not taking care with your toys. And the reason or the logic behind that is the next sentence. It says, one reason for basing liability upon fault is a belief in its deterrent effect. People will be more inclined to be careful if they must pay for the consequences of their carelessness. And so, generally in tort law, what we look for is to try to make the person who caused the loss improperly or wrongly responsible to pay damages or to compensate for the loss suffered by the victim of the tort. Any questions about any of that before I move on? Okay. Well, that's all fine in theory, but nowadays, especially when it comes to businesses, most businesses have liability insurance. So in my earlier example from today, if my business's employee carelessly drives the vehicle owned by the business, my insurer will respond and pay for the loss. It says that in the last two lines on page 75, many activities triggering tort liability are covered by insurance. And so the deterrent effect, the incentive for people to be careful in order to avoid being responsible for the loss, is not as effective as it used to be. There's another potential problem with focusing on fault, and I'll be discussing that with respect to material on page 76. Imagine that a group of people who are all related to each other, uncles, aunts, nephews, nieces, brothers, sisters, parents, children, they all gather together somewhere in a rural area on a farm and have a picnic together. And it's just some vacant farmland, and they have a wonderful time. They each bring some food and enjoy each other's company, and eventually a very informal baseball game spontaneously develops, and they use a frisbee for first base and a pizza box for second base. And it's not a regular baseball field, it's just a vacant piece of farmland, and they don't set up the bases the mandatory Major League Baseball distances apart. Everything's very close together, and the pitcher is lobbing the ball underhand towards the pitcher, and everyone takes turns with the at-bat and pitching and fielding, and they're all having a wonderful time. And up to the plate steps one of the members of this family, a big, tall, strong Jethro, who, with all his might, when the ball is lofted towards him, he swings, and unfortunately, the bat slips out of his hands and flies through the air and hits his aunt, who's sitting nearby watching, directly in the forehead, and causes her to be paralyzed for the rest of her life. This actually happened, and it was recorded on video, and the aunt who suffered the loss went to court and sued everyone involved with the party, the organizer, the owner of the land, Jethro, who swung the bat, and anyone else who in any way contributed to the fact situation. And in the end, after a trial, the judge and jury decided that no one was really at fault. No one was wrong. It was just a plain unfortunate accident. And so turn to page 76 and look at the paragraph that starts with the word a compensation. The second sentence says, accident victims who cannot establish fault on the part of some other persons go uncompensated. And so the poor aunt, who was a victim of this bat being hit in her forehead and giving her paralysis received no compensation because she could not prove that anyone was at fault. And so a fault-based system is not perfect, but it is for many areas of tort law the approach that is used. Yes? No, the fault does not need to be intentional. And I'm going to eventually, starting on page 78, look at intentional torts and various kinds where the wrong is done on purpose or intentionally. And then eventually we will get to the topic of unintentional torts, where it's not done on purpose. It's carelessness in most cases. So I'll just have to let my more detailed response to your question unfold in the next few pages. So let's start with a concept of strict liability and have you read right now illustration 4.1 on page 76. That example is there to help you remember the sentence immediately above illustration 4.1. It says, a person who collects potentially dangerous substances or materials on his land which accidentally escape is liable for any resulting damage, even if he's blameless. So there are some kinds of torts that use the concept of strict liability. That focuses on causation. If you've caused the loss, you will be responsible. And the law that's used, the case that's used as a real-life case is Rylands and Fletcher. You do not have to remember that case name. Someone had a big pond of water on their property that they had constructed. The pond leaked and damaged their neighbor. And the court said, if you create that situation, you will be responsible when something goes wrong. And so, better than the pond example is what it says immediately below. It says, underneath that illustration, some activities are inherently dangerous regardless of the amount of care taken. For example, transporting explosives. It seems logical that a person knowingly undertaking an inherently dangerous activity should be strictly liable for resulting damage regardless of fault. Why? Because they could charge for their services according to the degree of the risk, and they could carry adequate insurance to compensate for the possible harm done to others. In other words, if they were carrying explosives as part of their business, they would charge enough to make sure they used every appropriate precaution. But generally, our court system in Ontario and Canada does not impose strict liability on business. See the next line. It says, in the absence of legislation, Canadian courts typically consider fault to be the primary basis of liability. However, the expected level of care rises as the danger increases. And then they conclude at the end of the paragraph, the effect is much the same as if they were strictly liable. To help you wrap your minds around how careful one must be, turn to page 85 and then we will return to page 76 in a moment. Because I'm going to encourage you on page 85 to record some notes in the margin in your own handwriting immediately below the definition of standard of care. Underneath that definition, you should write likelihood of harm, degree of harm, likelihood of harm, degree of harm, utility of activity, and feasibility of eliminating risk. Likelihood of harm, degree of harm, utility of activity, and feasibility of eliminating risk. And we'll come back to that later today, because those are the factors that courts consider when they need to decide whether someone was appropriately careful. Turn back to page 76. Because some serious, yes, and at any time if you miss some of the words I say, you can always check the recording. Likelihood of harm, degree of harm, utility of activity, and feasibility of eliminating the risk. I don't mind repeating myself. Please don't misunderstand me. But if at any point in time you say, boy, I didn't get that, I missed some things, the recording is always there to supplement the real-time lecture. So turn back to page 76. And some serious legal thinkers have said focusing on fault is inappropriate, because really what we want to do is make sure that victims get compensated. Look at what it says at the bottom of page 76 in the last two lines. The most radical policy proposal would eliminate lawsuits for all personal injuries and compensate victims through a government-run compensation scheme. And so some people have argued that we spend an unnecessary amount of time with a blame game saying who's at fault. And it takes a lot of time and resources for court cases to go through the system to determine who's at fault. Why not just not spend money on that part of the process and use all of the money that's available to compensate people? That's the rationale behind the idea of a no-fault system. That's discussed on page 77. And there is one area of activity in our business world, and that's discussed in the fourth line, the scheme that's governing workers' compensation in Canada. People have said, and now the law and the system provides, that employees should get compensated whenever they get hurt at work. See the last four lines of that first paragraph. It says employers must contribute to a fund that is used to compensate workers injured in accidents, even when the employer is blameless and the injury is the result of the employee's own carelessness. And so what we have now is a situation where workers generally, not in every circumstance, but generally in most industries, get compensated. As long as they're hurt at work, they get compensation regardless of who's at fault. We now return to the idea of vicarious liability, and that was discussed earlier today at pages 388 and 389. Beside the heading vicarious liability, you should write, see page 230, because later in the text at page 230 is some further information, and also write beside the heading vicarious liability, see pages 388 and 389. The authors introduce the topic this way. It says, one example of strict liability in response to societal pressure relates to torts committed by employees in the course of employment. Next paragraph. Employers without fault may also be liable for harm caused by the acts of an employee when those acts arose as in the course of employment. An employer may even be found to be liable when he's given strict instructions to take proper care or not to do a particular act that causes the damage. And then in that paragraph it says this principle is called vicarious liability. And that's defined in the margin as the liability of an employer to compensate for torts committed by the employee during the course of employment. Figure 4.1 illustrates that. And beside the box that has the B in it, B as in baby, you should write even a blameless employer. Even a blameless employer. And make a note to yourself to study the words that are underneath that diagram, figure 4.1. V is the victim. A is the employee who hurt the victim, and B is the employer. And then somewhere near that figure you should write, see the salmon test, page 389, and earlier today I presented that to you. There's two reasons why even a blameless employer will be responsible for vicarious liability. And there's a paragraph underneath the figure that starts with the words, there are two public policy reasons for taking this approach. In the margin you should write number 1 beside that paragraph, just and practical remedy for victim. Number 1 is just and practical remedy for victim, and number 2 is benefit/burden. Benefit/burden. Here's how the authors explain it. They say, first, although an employee is personally liable for the torts he commits while acting for himself or for his employer, employees often have the limited assets available to pay for compensation for the potential harm they cause. And so in my example from earlier today, if the young man who is driving my pickup truck for my lawn cutting business carelessly hurts some person while they're driving my business's vehicle, the poor soul who was hurt by the carelessness is probably unable to collect the loss from my young man driving my pickup truck who cuts grass for a living. So in addition to collecting from the person who caused the loss, the employee, the victim also has the ability to collect from the employer, who usually has money. Second, it says in that paragraph, it seems only fair that the person who makes the profit from an activity should be liable for any loss. And in law, there's a general approach, not always, but generally, a person who benefits from a certain activity should also bear the burden of things that might go wrong with that activity. And so, if I'm going to use employees to make a profit cutting people's lawns, if any of those employees make a mistake, like negligence or carelessness, I as the employer should be responsible for their mistake. Everything okay for us to move on to page 78? If I don't see a hand up, I will do that. All right. Well, starting on this page, we will quickly go through intentional torts. Look at what it says at the top of page 78. Torts are divided into two types, intentional and unintentional. Intentional torts are those where the activity or conduct is done deliberately, not by accident. Unintentional torts are where the harm might be unexpected. It says in both cases, the harm might be unexpected in the fourth line, and the intention relates only to the behavior, not resulting damage. And so as it says in the first bullet point on the slide, when it comes to intentional torts, what we focus on is the intention to do the act, not the intention to cause the damage, but the intention to do the act. And the authors give you an example in the first paragraph on page 78. And one of the things you will see that is required is in the next paragraph, harm or damage must occur for the tort to be actionable. And by actionable, they mean someone starts a lawsuit and succeeds to recover for their loss. And so over the next few pages, we will quite quickly review a series of different kinds of torts that are intentional torts that are relevant for business, like assault, defined in the margin, page 78 as the threat of violence to a person. And battery, the unlawful physical contact with a person. So if I touch you without permission, that is a battery. Another kind of tort is nuisance, and I want to focus your attention on page 79 on private nuisance, defined in the margin as interference with an occupier's use and enjoyment of her land. In the main text beside that it says, the tort of private nuisance protects an occupier's right to the reasonable use and enjoyment of her own land without substantial interference from direct or indirect activity on neighboring property. And an example that I use is from my early years as practice as a lawyer. We represented a mushroom farmer in a rural area, and neighbors of the mushroom farmer complained because the process of making compost on which mushrooms grow is a pretty smelly operation. You combine often animal wastes and decaying plant matter, and you mix them together and you turn them over every once in a while so that they turn into compost. And neighbors said, this is not fair. The smell is preventing me from using my backyard pool and having a barbecue in the summer. I am going to sue you for nuisance. So should they win? Well, it's discussed further on page 79. In the third paragraph it says, an occupier does not have a right to absolute freedom from trivial annoyances. And after class you should read the examples that are in that paragraph. It says in the fourth and fifth lines that the level of interference that a community as a whole already tolerates and that individual members of it can be expected to tolerate also varies according to local conditions. And then when you read the examples, you'll see what that means. Another kind of tort is false imprisonment. Page 79 in the margin, unlawfully restraining or confining another person. And over on page 80, false arrest, causing a person to be arrested without reasonable cause. And finally, on page 80, you should write, not finally, but also on page 80, beside the definition of malicious prosecution, you should write rarely successful. When someone is charged with an offense, if in due course they're found not guilty, that does not mean they will succeed in suing the police officer and the prosecutor. Look at that definition. Causing a person to be prosecuted for a crime without an honest belief that the crime was committed. If you want to succeed in malicious prosecution, you need to prove that the prosecution and or the police prosecuted you in bad faith, and that is not easy. Another kind of intentional tort is defamation. Look at that in the margin. Making an untrue statement that causes injury to the reputation of another person. Imagine that you and I are sitting alone in a room, and I say to you, you are a liar, and you can show that that's not true. I cannot prove that you're a liar. Let's assume that. That would not be defamation if the only people in the room are you and I. Take a look at the third last line of the paragraph, the first paragraph under defamation. It says, defamation torts require publication, that is, communication of the offending written or oral statement to someone other than the person being defamed. So if we were sitting in a room full of people, me and you and a bunch of others, and I said in front of others, you are a liar, and that's untrue, that would be defamation. Look at the next paragraph. One defense against defamation is the alleged defamatory statements are true. So if I could prove that you have lied in the past, then I might defend myself for calling you a liar. And there are other defenses. One such defense is absolute privilege. Look at that definition in the margin. Complete immunity from liability for defamation. So imagine that I am a witness in a court trial, and one of the issues in the trial is whether or not someone was a liar or a thief. And I get questioned under oath while I'm a witness at the trial, and I testify, and I reach the exciting conclusion of my testimony where I conclude that so-and-so is a liar and a thief. At the end of the trial, if the judge and jury decide that they are not guilty, my statement in court is protected by absolute privilege. See what it says in the third and fourth lines of the paragraph where we left off. Words spoken in parliamentary debate, in proceedings in law courts and inquests, and before royal commissions are subject to absolute privilege. And so the person who I said was a liar and a thief when I testified in court could not successfully sue me. I would have a complete defense or absolute privilege defense for my testimony in court. If after the trial on the courthouse steps a reporter put a microphone in front of me and I repeated the statement, that would be defamation. You're only protected while you're involved in a trial or a parliamentary debate or that kind of thing. Another kind of privilege is qualified privilege. In the margin, that's defined as immunity from liability for defamation provided a statement was made in good faith. And in the third paragraph under the heading defamation, the authors give the example of a letter of reference. Imagine that you as a manager in a company are asked to give a letter of reference for one of your employees. If you say something in your letter that proves to be untrue, you will probably be protected by qualified privilege. Look at the last three lines of that paragraph. Consequently, the law gives a qualified privilege to anyone giving such information, provided he gives it in good faith and with an honest belief in its accuracy. He's not liable for defamation, even if the statements turn out to be untrue. And in a relatively new development in the law, the court has, by rulings in the Supreme Court of Canada, developed something called responsible communication of matters of public interest. That is something that's now sometimes called the fair comment defense that applies mostly to journalists who have researched a topic and then offer their opinions. Look at the last two lines on page 80. It says, a reasonable opinion, honestly believing it to be true, and that's the defense of responsible communication on matters of public interest. The next topic, still intentional torts, or economic torts, and I want to quickly go through an idea in the margin on page 81, inducing breach of contract. The authors give you an example in the second paragraph under the heading Other Intentional Torts related to business involving parties A and B and C. And in short, when one person convinces someone else to break a contract, then if they intentionally take steps to induce or cause someone to break a contract, the victim of the breach of contract can sue not only the person who broke the contract, but they can also sue the person who induced the breach. So for example, if I bribed someone who had a contract to break their contract, or to cause the business to break a contract, not only can the victim of the breach of contract sue the person who broke the contract, but they could also sue me because I induced the breach by giving a bribe. And another term that's defined in the margin on page 81 is unlawful interference with economic relations. The key words in that definition are unlawful means. You should underline the words unlawful means in that definition. And a bribe would be another example of that. On page 83, the heading is unintentional torts. Earlier I was asked, do torts need to be intentional? And the answer is no. See what it says at the top of page 83. It says, unintentional torts involve behavior that is not done deliberately or on purpose. Last sentence of the paragraph, it follows that the resulting harm is unintentional. And the best known unintentional tort is negligence. Look at that definition in the margin. The careless causing of injury to the person or property of another. Just by being in our society here in Ontario and paying attention to news stories, you probably have a fairly good general idea of negligence. See what it says under that heading. By far the most common basis for legal actions in tort, and the one that best illustrates the fault theory of liability, is negligence. And so to go back to vicarious liability, if an employee negligently hurts somebody, the employer will be responsible for the loss, and that's called vicarious liability. So what do you need to prove for negligence? That's described under the heading Elements of Proof. And there are certain questions the authors pose under that heading. The first one is in the second line after the long dash. It says, should the defendant have been aware of the risk of harm to his victim? Generally, that's one thing to look for. The second element is the second long dash in the fourth line. Did the defendant's conduct fall below the standard of behavior required under the circumstances? We will look at that. And then it says in the last two lines that the third and fourth elements involve what harm was suffered and whether the defendant's conduct caused the plaintiff's injury. And we will, in a very logical and methodical way, explore all of those questions. In the margin on page 83, beside the checklist, you should write three words: fault causing loss. Fault causing loss. Because three simple words that will help you understand and remember the checklist elements of a negligence action are fault causing loss. Draw a bracket around items 1 and 2 in that checklist and draw an arrow from that bracket to the word fault. Next, draw an arrow from the word loss to number 3 and draw an arrow from the word causing to number 4. And so you will see today that items number 1 and 2 combined are the fault element. Number 1 is that the defendant owed the plaintiff a duty of care. Number 2, the defendant breached the required standard of care. Those two things combined would mean someone's at fault. Number 3, the plaintiff suffered injury or damage. And number 4, the plaintiff's conduct caused the plaintiff's damage. And over the next few pages and over the balance of today's lecture, we will examine each of those items in detail. The first is duty of care. And somewhere nearby the definition of duty of care, below it is probably a good place. You should write the word foreseeability. Foreseeability. Duty of care is defined in the margin as a relationship so close that one could reasonably foresee causing harm to the other. And the concept that helps you understand that is foreseeability. Another way of thinking about it is under the heading duty of care in the main text, look at the second sentence. Duty focuses on the relationship between the parties. Well, in contract law, you define the relationship based upon the parties making a contract. But in tort law, there is no contract. The parties have not agreed to be careful when dealing with each other. Our law imposes an obligation to be careful as a result of the relationship. And the relationship is defined by the two bullet points on page 4, the slide 4-14 that you see on the screen, proximity and foreseeability. And those things combine to result in some sort of relationship in tort law. Here's what we mean. It says in the third paragraph under the heading duty of care, the last paragraph on page 83, first, the closeness of the relationship between the plaintiff and the defendant is examined to see if it was reasonably foreseeable that the conduct could cause harm. And there's a mistake in the textbook. The authors or the editors have mixed up some words. The word just before conduct should not read plaintiffs, it should read defendants' conduct. And the last word in the sentence should not read defendant, it should read plaintiff. In other words, it was foreseeable that the defendant's conduct, the person who's being sued for negligence, that their conduct would cause harm. I'll give you an example to help cement this into your mind. And that's known as proximity. So it's the combination of proximity or closeness and foreseeability that combine. Here's an example. Imagine that later this year, it's exam time, and you are supposed to be carefully studying your text notes for this course, but you can't because it's a beautiful day outside. You and your other friends in this course decide to meet in a park and have a baseball game. Not in a baseball diamond where people ordinarily play baseball, but in an ordinary park where there's all sorts of different people walking around. It's not intended or designed for baseball, but there's some open areas here and there. And you use a frisbee for first base and a pizza box for second base, and the textbook for home plate, and spontaneously a bunch of students from the university engage in a very informal baseball game. You are standing in the outfield waiting to catch and field the ball, and a ball gets hit towards you and lands at your feet. You pick up the ball, and when you hold the ball in your hands and you peer towards the place where you want to throw the ball, home plate, to get the runner out at home, you see all sorts of people. You see profs walking by, you see mothers pushing babies in their baby carriages. There are many different people all enjoying the park. And despite seeing people walking around near where you're playing baseball, you decide to throw the ball as hard as you can in order to reach home plate to get out the runner. Unfortunately, your throw is not good, and carelessly your throw hits somebody. The circumstance of being in the outfield and seeing that your action might harm others is foreseeable. And those others who are close enough physically to get hit by your bad throw, the combination of proximity and foreseeability make you have an obligation to be careful. See the last two lines of page 83. It says the duty will arise only when an ordinary person, sometimes called a reasonable man, in the defendant's position could have foreseen a risk of harm. Right at the end of that clause, foreseen a risk of harm, you should write, not the particular harm. Not the particular harm. So you don't need to have foreseen the exact person that you might hit with a baseball, or the exact loss or harm that might be caused. As long as you can foresee that your actions might cause some harm to somebody, that is sufficient to cause you to have a duty of care. Turn to the next page, 84. And then it continues, to the plaintiff or someone in the plaintiff's position. And at somewhere near the words in the plaintiff's position, you should write, not the particular victim. So it's not necessary for you to be able to foresee with precision the precise victim who will get hit by the ball. As long as it's apparent to a reasonable person that a bad throw will hit someone who's enjoying the park, that foreseeability imposes a duty of care. The sentence, or the paragraph, finally ends with the key words are proximity, meaning closeness, and foreseeability, meaning predictability. So those two things combine to create a duty of care. And on page 84, the authors say in the second paragraph under the words Supreme Court of Canada, a quote from a recent famous case. It says, whether a relationship exists depends upon foreseeability moderated by policy concerns. And that's a quote from a famous case from Windsor, Ontario, called Mustafa and Culligan, which we will look at in this chapter later on. Next, how much care? Page 85. You should write that question on page 85. You should write how much care near the heading standard of care. How much care? Standard of care is defined as the level of care that a person must take in the circumstances. And in the second paragraph under the heading standard of care, it says that the law places a general duty on every person to take reasonable care to avoid causing foreseeable injury to other persons or their property. So you must take reasonable care once there is a duty of care. Or as it says in the definition, care that a person must take in the circumstances. So the particular circumstances are relevant, and the circumstances mean you need to consider the likelihood of the harm. In other words, if harm is highly probable, then you need to be more careful. The degree of harm, the bigger the harm that might be caused by your conduct, the more careful you must be. The utility of the activity and the feasibility of eliminating risk. So for example, we could eliminate all motor vehicle accidents by eliminating motor vehicles. We could say, you know what, we don't want car accidents, let's just get rid of all the cars. Most people would say that's not a good solution. And similarly, eliminating all baseball games to avoid anyone ever getting hit by a baseball is extreme. But causing or requiring people to be careful when they're driving their cars or when they're playing baseball is not an unreasonable requirement. See the third paragraph under the heading Standard of Care on page 85. It says, a defendant need not take all care, only reasonable care. It may not be practical to take every possible precaution where the risk of serious damage or injury is small, but where there's a danger of a major catastrophe, it would be unreasonable not to take every known precaution. It is the combination of a duty of care and a standard of care that together might result in fault. So if someone has a duty of care and they fail to meet the reasonable care required, then they will be at fault. So that's one element that needs to be proved for a tort like negligence. The third element is damage. And at the bottom of page 85, beside the paragraph that has the heading damage to the plaintiff, you should write, a loss is required. No harm, no foul. You might have heard this saying, no harm, no foul. And what we mean is, if someone has done something carelessly, but there's no loss that has resulted from the carelessness, then there's no negligence. So if you are in the outfield and you throw the ball as hard as you can, and fortunately it hits nobody, it flies over the home base and flies over the heads of everyone who's walking in the park, and nobody gets hurt, then there's no negligence, because there's no harm. See what it says in that last paragraph on page 85. Damage focuses on the type of harm or injury actually suffered. Damage or loss is always a requirement of tort liability, as compensation is the goal. And so, if no one has suffered a loss, then even if there's carelessness, it's not actionable. Or as the authors say at the top of page 86, it must actually be sustained, not hypothetical. So there must be some sort of real loss. The next and final element that I'll present to you is causation. Causation is defined in the margin as injury resulting from the breach of the standard of care. It says this in the main text. Causation focuses on the strength of the connection between the harm suffered and the behavior of the defendant. And so you may have heard people say that the flapping of a butterfly's wings in Japan could cause a change in the weather here in Windsor. Some people have a view of connectedness that is, that everything is connected. But for law purposes, look at the end of the paragraph, the last sentence. The test for legal causation is much narrower. And so one element that must be proved is that the behavior, the act of the wrongdoer caused the loss. Look at the second paragraph under the heading causation of damage. It says the basic test is known as the but-for test. The plaintiff must show that but for the negligent conduct of the defendant, the injury would not have occurred. So you should read after class the balance of that paragraph. They further explore that with example. And then in the paragraph underneath case 4.3, they also describe a different causation concept called material contribution test. And when someone creates an unreasonable risk of loss, they might be held responsible based upon that kind of causation. And they give you an example there. I want to move on to remoteness of damage, and I will continue the lecture today until we complete the discussion of remoteness of damage near the bottom of page 87, and then I will finish for the day. So we've got about 4 minutes or so, or 5 minutes to get there. And this idea of remoteness of damage is a way that courts can limit damages beyond the tools of the duty of care and standard of care. I'll give you some examples to make it clearer. Under the heading remoteness of damage, look at the third line. It says, he may not be considered to have legally caused the injury if it is too remote. What do we mean by that? Well, there's a famous case that started in Windsor called Mustafa and Culligan. It's summarized in case 4.8. I'll quickly give you the facts. You can read it after class. A consumer purchased a bottle of water from a company called Culligan. It was sealed. And in the process of taking the bottle of water and putting it onto a dispenser, before they actually put it on the dispenser, they noticed a dead fly in the bottle of water, and it very much upset the purchaser of the bottle of water, and he sued Culligan for the mental suffering. A trial happened in Windsor, and as the case says, the judge awarded $340,000 to the person who saw the dead fly in the bottle. Eventually, the Supreme Court of Canada says, even if everything that was described to the court was true, we will not permit that large amount of money to be awarded to someone who merely saw a dead fly. Look at the end of the paragraph. The plaintiff could not recover because the damage was too remote. And so somewhere near that case, you should write not responsible if too remote. Now go back to the bottom of page 86. Reasonably foreseeable, it has said in the last two lines, has been defined as a real risk, one which would occur in the mind of a reasonable man in the position of the defendant. He would not brush it aside as far-fetched, and a court undertakes an objective assessment, it says at the top of page 87, from the perspective of a normal victim, a person of ordinary fortitude. And so what they're saying is, a person of ordinary fortitude, a normal victim, would never have this crazy, extreme reaction to seeing a bottle of water with a fly in it, because this particular plaintiff, Mr. Mustafa, said that he could not shower, he could not drink water, he was so upset that he could not have sex with his wife. His damages that he claimed were incredibly large from seeing this fly, and the court said, that's too remote. And the final point I want to cover with you is a qualification to that. Look at the paragraph that follows the case. It says, the reasonable foreseeability test referred to in case 4.8 should not be confused with the legal doctrine of thin skull or eggshell plaintiff, which requires a defendant to take the victim as he or she finds him. In the margin beside that passage, you should write Humpty Dumpty to help you remember this example. You're in the park, the ball has been hit to you, you pick up the ball and hurl it with all your might, and you end up hitting a large egg-shaped fellow who is sitting on a wall in the park. You didn't see that particular individual. You saw all sorts of people. You knew that someone might get hit with the ball and maybe they would get a bump on their head, but you didn't anticipate hitting this egg-shaped fellow. But you did with your bad throw. See what it says in the paragraph below the blue quote. It says, the thin skull doctrine allows the injured plaintiff to recover all of his damage, even though they may be much greater than an ordinary plaintiff would have suffered, if the type of damage is considered reasonably foreseeable. The court will compensate the victim for his actual damage. And so you're standing there with the ball in your hand. You foresee it's possible that a bad throw might hurt someone. Maybe it would hit me in the head as I walk by and give me a bump on my head. If physical damage to someone like a bump on the head, is foreseeable. If your bad throw ends up causing more serious damage, that is the thin skull or eggshell plaintiff rule. So imagine that you hurl the ball with all your might. The bad throw that you made hits a little 1-year-old who's being pushed in a baby carriage by the mother, rendering that baby a paraplegic and causing that baby to need care for the rest of their life, costing millions of dollars. If it was foreseeable that some damage from a bad throw could happen, you will be responsible for all the damage that you actually do cause by your bad throw. That's the thin skull doctrine, or the eggshell plaintiff doctrine. And that's captured in the quote on page 89, the blue quote. That is where we will leave it for today. Thank you for your attention.